Hello, everybody. I'm delighted to be here today with Gwyn Hopkins of Perun Consultants and Calvin Ho, a partner at Charltons, to talk further about restructuring options. Today's webinar is the second of three we're hosting. In the first webinar last week, we talked about how to identify financial distress in corporates, as well as practical and legal considerations to deal with these difficult situations. In today's webinar, we'll talk about three main areas. The first is informal workouts, including formulating a turnaround plan, doing debt restructuring and/or equity-based restructuring. The second is court-assisted restructuring, where we'll discuss issues relating to Hong Kong schemes of arrangement and also the offshore light-touch provisional liquidator route. Finally, we'll also look into the methods and procedures for different liquidations in Hong Kong. In the third and final webinar next week at 5 p.m. on Wednesday, the 31st of March, we'll be focusing on different restructuring mechanisms and the regulatory requirements for Hong Kong listed companies. Before we start the webinar today, I'd like to introduce the two speakers who will be joining me today. Gwyn Hopkins, he's worked as an insolvency practitioner and forensic accountant on a wide range of local and cross-border engagements. In addition, Gwyn has extensive experience in forensic accounting assignments, including asset tracing and recovery arrangements, due diligence investigations, and the preparation of loss of profits and asset valuation reports. Gwyn also takes roles such as acting as a consultant or an appointed independent director or trustee to assist distressed entities. Having previously spent over 20 years working between Hong Kong, Cayman, BVI in the UK, in 2017, Gwyn formed Perun Consultants, a boutique accounting firm specializing in the areas of forensic accounting, corporate advisory, restructuring, turnaround, and liquidation appointments. Calvin Ho, one of Charlton's partners, has over 15 years extensive experience in corporate finance and commercial transactions. He regularly advises on restructurings and has extensive experience relating to projects in various jurisdictions. Now, over to Gwyn, who'll start today's webinar.
Thank you very much, Julia. It's a pleasure to be here. I should say before we get deep into this, you'll see the slides coming through. At the end of the session, you will be sent copies of the slides. So don't worry if we skip over some of the slides. I'm certainly not going to be reading them verbatim, but there's no need to scramble around taking notes. The slides will be sent to you at the end of the session. So we're going to be covering today the financial restructuring process. We've already covered in the previous webinar issues concerning about recognizing the issues of distress. Now let's talk about how one is going to deal with it. And a lot of it's going to come down to proactive and engaged approaches to deal with these issues. Let's start with talking about the informal workout process. Now this is a consensual arrangement. This is proactively going out to the various creditors and trying to work out deals to help the company through its difficult period. The idea being that this can be very flexibly done, and it's a timely measure, I say, to proactively engage with the individual creditors. There's obviously much less regulatory involvement here, and it's considerably less costly because one is not going through the formal workout processes or indeed an insolvency process, and therefore you don't need quite so much heavy lifting from the professionals. The thing with this, though, is, as I've mentioned several times, you've got to be proactive about this. It's no good waiting to the last minute after you've already missed a whole bunch of debt payments, etc., to suddenly go around to the creditors and try and get agreement. This does require the company and management to have actively recognized there's an issue and come up with a viable set of solutions to deal with the issues that are facing the company. Again, one of the issues with the informal process is that it's not something you can force on creditors. You've got to therefore approach the negotiation on the basis that this is a positive engagement with them, not just expecting them to take it or leave it. One of the key aspects to that, again, is making sure that you do have a viable plan. It's no good just asking for a 6-month delay in payments if the underlying issues affecting the business are not in fact going to be addressed. one has to be able to persuade the creditors that the deal that is being negotiated between you and them is actually going to be a better outcome for them than going through any of the formal proceedings. Now, the advantages of the informal workout are sometimes offset by the fact that where you have a disparate group of creditors, it can be very difficult to get the sufficient number of agreements that you need in order to get a beneficial outcome for the company. These sort of arrangements tend to work better when you have a homogeneity of creditors. And it's, again, also much harder to deal with when you have creditors. For example, certain banks, they're not very keen on certain business sectors. There are some banks here in Hong Kong whose primary preference is property and related investments and security. And so when you're trying to make arrangements with them for businesses that are more in the service sector, it can be very difficult to persuade them to see the advantages of the more informal approach. And so this is not necessarily a solution for everybody, but I say when it can work, then it can work very effectively. Turning on to the next slide, just to look at some of the approaches that you're going to have to take, whether it's an informal arrangement or indeed any other approach to life. The establishment of the company's financial position, its projections on how it's going to perform and what the plan is going to be. This is a crucial aspect throughout. There's no creditor is going to be willing to just kick the can down the road and hope for the best. So you're going to have to show, again, an engaged, viable solution. And to do that, you have to properly diagnose the problem. And so with the assistance of professional advisors, you can work out not just what the current financial position of the company is, but what's its short-term cash needs. Short-term cash is often the most crucial aspect to these scenarios, because a company may well indeed be viable long-term, but if it's facing a cash crunch, it can't meet its short-term debt payments, then it doesn't survive long enough to make it through to the more productive and successful aspects of its business. So one has to then drill down into what are the fundamental issues that are driving the company's difficulties and underperformance, and then how those are going to be solved. For example, if the company was heavily dependent upon a single customer, and that customer itself has gone bust or facing difficulties itself, it's no good just saying, well, the company will be fine, we just need a bit of support to get through this trying period. You're going to have to say, what are our solutions to this? How are we going to be able to spread our customer base so that we can make up for that shortfall from the lack of that key customer going forward? Or equally, maybe the company has to reduce the degree of its trading, so that will obviously reduce its turnover, but also limit its costs. There are, any number of ways to look at it, but you have to diagnose what are the fundamental problems. And then, as part of that process, you're also looking at the key stakeholders. Of course, one thinks about the creditors, but those are not all uniform. Even when you only have a small number of creditors, there'll be some that have security. There are different forms of trade creditors. Some of those are going to be absolutely crucial, particularly for manufacturers. If there's a particular supplier that supplies the only part that is a crucial component to your product, then it's going to be very, very important to keep them on board. And then there are maybe other stakeholders. Employees, of course, need to be borne in mind, and indeed the shareholders. And we'll come back and talk about them in a moment. And this is where having an independent financial advisor step in to assist can help take a lot of the burden off the management, who also at the same time as doing this, you still need to keep the business running. So if we're looking at, for example, the balance sheet of the company, again, we won't go through this line by line, but just to give a view of where one might be looking, you start with the fixed assets and a quick inventory. Are there any redundant assets, things that are capable of being disposed of without harming the business? Obviously, resale prices are going to vary depending on the nature of the assets, but it's something to look at. where you have things, investments on the books and other sort of more financial assets. There are ways to monetize those and more efficiently release some of those assets to the company, again, to fund its short-term cash requirements without harming the business's longer-term prospects. And to the extent realizing those assets does harm the long-term prospects, well, then you have to do a trade-off analysis. It's all no good having long-term prospects if you're not going to survive the short term. So one has to do an analysis of risk-reward and trade-off there. Cash, obviously, cash is nice to have on the books, and one would hope one has plenty. But clearly, if you're in distress, one of the issues is how long is that cash going to last? When you're dealing with companies that have that form part of a group, one also has to look at where is the cash held, and maybe it would be better to pool it or to reallocate that cash to other parts of the group. This again has to be done somewhat carefully because particularly if you're in an area of insolvency, there are obviously exposures that we will need to cover to make sure the directors are not expose themselves to unnecessary risk. But certainly cash management, not just in terms of, let's say, raising cash in the company itself, but cash management within a group structure is also something to look at very carefully. And then in terms of the liabilities, well, obviously part of the workout process is to try and restructure those, whether that be a moratorium on the payments, reduction in the interest rates, longer timelines, etc. And we will cover some of those options in more detail later. Similarly, if you look at the P&L account and the company's cash generation, things to look at there, again, as part of identifying what are the company's drivers, what are the problems that are arising, and what can be done to minimize those costs whilst limiting the harm done to the company's turnover. This obviously requires a very careful assessment and review of the company's financing needs and its capital structure, and what will be its best outcome at the end of a turnaround process. So having looked at the issues, one then has to come up with a plan. And the key issue for the plan is to be able to demonstrate to the stakeholders that the company is proactively taking action to improve performance, and it's actually got a sensible, workable plan, not just an aspiration that things will get better somehow. You can certainly expect that creditors, to the extent that they are cooperative and helpful in this process, will want to have some oversight to make sure that having given up some of their rights or traded them for reduced terms, etc., that they will expect to have some oversight that the company is carrying through on the plans that it said it would, and that those plans are in fact bearing fruit in the way expected. Again, as I mentioned earlier, the big thing is, particularly on the informal approach, early is a crucial aspect of this. It's no good waiting to the last minute. You have to be talking proactively with the creditors and the other stakeholders to get their buy-in and to achieve the results that are mutually beneficial. You should also, wherever possible, try and have a couple of fallback plans. Not every creditor is necessarily going to agree with the informal workout process. That will then lead to potentially other actions, which we'll cover in a few minutes. But because the nature of the informal process is that you cannot force creditors, it is a negotiation. You have to be braced for the fact that some creditors are not going to be cooperative. And is the plan going to be successful if you get some holdouts? This is something that needs to be looked at. If we look now at some of the debt restructuring options, this is obviously going to depend upon the nature of the debt that you've got on the books, but there are sort of three main areas to look at. So one, obviously, there's the rescheduling of the debt itself and amending its terms. You could try raising new finance on better terms to help clear the old debt. When we talk about new financing on better terms, obviously the obvious things that leap to mind are lower interest, longer repayment terms, etc. But also a consideration is getting a lender who is more attuned to the nature of the industry in which you operate. As I mentioned earlier, there are some providers in Hong Kong that are much more comfortable with property, much less comfortable with service industries, for example. And so if you're raising new finance, you certainly want to look at finding lenders that are more happy with the specifics of the industry you're in, and that helps with the discussions going forward, and indeed is often leads to a better creditor-debtor relationship. Another obviously option is to look at writing off the debt or converting debt to equity. Now, of course, the shareholders themselves will probably have some issues in relation to that. They won't want to be diluted. This is why one should also consider when looking at the options is your existing shareholder base. Are there people there who are willing to put in additional funds? And maybe they even have some connections with some of your crucial creditors. If you do, again, the informal workout is a negotiation. So I find a lot of it's on commercial terms, but there's still a personal relationship that develops. A lot of negotiation involves personal connections. And so, if one of your major shareholders happens to have connections with one of your major creditors, subject to obviously discussing the position with your lawyers, it's certainly worth considering whether those shareholders are going to be helpful in engaging with those creditors. And there are other obviously debt restructuring options. We have the list there. I'm not going to read through all of those. Again, just highlighting on that debt for equity swap basis that the shareholders may not want to be diluted. Of course, that may be the outcome that they're stuck with. But you should certainly engage with the shareholders and see to what extent they can assist. And now Kelvin and Julia are going to be talking about some of the aspects of security and securitization that ties up with some of these debt restructuring options, particularly the securitization of receivables and the sale and leaseback of assets, etc. Kelvin?
Thank you, Glenn. So Glenn has discussed several methods for seeking relief from creditors as part of debt restructurings, which may involve renegotiating existing credit terms, capitalizing outstanding debt into equity, among others. Where a distressed company has valuable assets which remains unencumbered, then it may also seek to alleviate the situation and raise funds to service outstanding contractual debt payments by either negotiating loans or margin facilities with new lenders, or negotiating with existing lenders to increase their commitments. In either case, unless the company is mature in terms of size or has the corporate support of affiliates such as substantial shareholders or controlling shareholders, then the lenders would likely require, in addition to any renegotiation of financing terms such as financial covenants and undertakings or enhanced reporting requirements, the creation of new or further security over its assets, or a renegotiation of terms of any existing security package or arrangements, such as adjustment to prescribed loan-to-value ratio. Where secured financing is considered a feasible option, then the company will need to determine which assets could be used to provide additional security to the lender, and to which the lender may potentially find acceptable. Some factors which a company may consider in determining whether to pledge assets to support its debt financing against other potential workout options include: first, whether the creation of new security would result in a breach of existing contractual undertakings under existing facilities or other material contracts binding on the company. For example, an existing facility may prohibit the granting of further security without first seeking the consent of existing lenders. Second, whether the creation of security may potentially impair its future capital raising capability. This is because a company with high debt ratio may make it unattractive to potential equity investors to invest. Third, the implications to the business and operations of the company of potentially losing control or ownership over assets being pledged or charged. In particular, the potential implications of the relevant assets being acquired by competitors seeking to enhance their market position if and when the security becomes enforceable. Fourth, rather than creating security over unencumbered assets, the company may consider various alternatives. For example, it may negotiate the creation of security over proceeds of a loan or over rights of existing credit support such as guarantees provided by affiliates. For instance, security could be created by assigning rights over a shareholders' loan agreement entered for distributing proceeds of the loans to operating subsidiaries. Another alternative to creating new security is seeking contractual subordination of security over assets already secured, where an existing lender may potentially agree to have the mortgage or liens subordinated to new lenders. And lastly, for listed issuers, any applicable legal or regulatory implication, such as takeover implications that may arise from potential enforcement of security. This will be discussed in webinar 3 of this Insolvency and Restructuring webinar series. Once it has been determined that security will be created over certain assets of the company, then consideration should be given to the form in which the security is to be provided. Security may be taken over both movable and immovable property. With regards to immovable property, common forms of security include legal mortgage, equitable mortgage, and fixed charge. With regards to movable property, common forms of security include mortgages, fixed charges, and floating charges. We will now discuss briefly how security is created over several main types of security assets, as well as relevant formalities taken to perfect the security. Security over immovable property, such as land and buildings, is typically taken by way of legal mortgage. This involves the transfer of title with a right to the mortgagor to redeem the mortgage property upon repayment of debt, but the mortgagor is typically permitted to continue to occupy the property. Formalities for creation and perfection of security include the execution of a conveyance deed, as well as registration with the company registry and the land registry within 1 month of the creation of security. Security over tangible movable property, such as office building and inventories, is typically taken by way of legal mortgage or creating a floating charge which crystallizes into a fixed charge upon the occurrence of certain pre-agreed events, such as signs of further financial deterioration or the commencement of proceedings for winding up. Unlike a pledge or fixed charge, whereby the pledgee or chargee has control over the charged property, these forms of security permits the debtor to continue to use and deal with the property. Formalities include entering of the relevant charge or mortgage and filing the same with the company registry. Filings with other registry may also be applicable. For example, a mortgage over registered vessels are required to be filed with the shipping registry of the Marine Department. Security over shares and debt securities is typically taken by way of mortgage or charge. Security by way of mortgage, which requires the transfer of title, is typically not possible for securities of listed companies if the legal title to shares are held and share certificates are immobilized in the Central Clearing and Settlement System or CCAS of the stock exchange. In terms of formalities, for a mortgage, the mortgagor must transfer legal title to shares, which is then recorded in the register of members of the company. Whereas for a charge, the legal title is retained with the charger. For perfection of security, share certificates as well as pre-executed but undated instruments of transfer, bought and sold notes, irrevocable proxies, undertakings, written resolutions, and in some cases, directors' resignation letters will be executed and delivered to the lender to enable it to effect the transfer of shares to itself in the event of default. For listed shares, the certificates of which are deposited into CCAS, security may be created by 2 methods. First, charging shares in the securities account together with a notice to the broker would be required to acknowledge the notice with undertakings to comply with instructions given to it by the chargee. Second, arranging shares to be transferred to securities account of the chargees or his nominees. In general, where shares of an SPV is set up to hold certain of the debtor's assets and such SPV is thinly capitalized, then it will be necessary to consider whether intra-group loans advanced by the debtor to the SPV would also need to be subordinated to the loans being advanced or security taken thereon by the lender. Security over claims and receivables, including cash deposits, trade receivables, rights of payments under specific contracts or insurance proceeds, could be taken by way of fixed charge. In this regard, it should be noted that if a chargee does not have control over the proceeds of the debt, such that the charger could collect and deal with the proceeds without the charge's consent, then it will be a floating charge until crystallization. Alternatively, security over claims and receivables could be created by way of assignment, which gives the assignee the right to take action against the debtor without joining the assignor. Under applicable laws, a statutory assignment of rights to debt shall be deemed to be effectual in law, provided that notice in writing has been given to the relevant debtor or other persons from whom the assigner would have been entitled to receive or claim from the relevant debtor. However, where it is not practical or desirable to identify all contracts or notify all debtors, then a charge, which does not require the giving of notice, would be preferred. In both cases, the security created would need to be registered with the company registry, except that a charge over cash deposits does not qualify as book debt and is not registrable. Security over intellectual property, such as trademarks, patents, and designs, can be taken either by mortgage or fixed or floating charge. And the formalities for perfecting security include registration with the company registry, as well as relevant registry of the intellectual property department, such as the trademark registry, patents registry, or designs registry. When determining which assets to be offered as security, as well as the form of security to be granted, both legal and commercial considerations should be taken into account when negotiating with the lender. For example, the complexity and formalities involved in creating security over assets in foreign jurisdictions should be noted. For instance, the creation of charge over real property in a foreign country may require notarization and certifications to be done. Also, when considering whether security over assets should be by way of assignment rather than a fixed or floating charge, the borrower should consider carefully the feasibility and commercial implications of sending notices to counterparties such as banks, brokers, customers, and clients in an assignment. In particular, whether it might potentially affect its relationship or terms of engagement with these counterparties. As a side note, a lender may typically require the conducting of legal and financial due diligence, as well as issuance of various legal opinions in respect of assets being secured. These may cover the right of ownership and title over the relevant assets, borrowing powers and absence of restriction under the company's articles for creation of security, fulfillment of legal requirements for perfection of security, etc. Where there is more than one lender, then it may be preferable for syndication of the loan as well as appointment of a security agent to deal with security arrangements. So we have so far discussed some debt restructuring options as well as creation of security for supporting such security financing. In the next few slides, we'll discuss another strategy for a company in financial distress, and that is to seek investments and raise funds from existing shareholders or third parties. This may be particularly appropriate if the company has a reasonable prospect of being sustainable or financial difficulty was simply caused by a misalignment of its financial needs. For example, where the company is attempting to fund long-term assets, such as plant and equipment with short-term sources of financing. Like any other equity investments, investors of distressed companies may consider the following. First, whether there are events on the horizon which may change the nature or increase the value of the invested company. Second, the strategy for cashing out, which may be through earning of capital gains from repricing when a company has recovered, or through the exercise of put options which may be granted. Third, the investor may consider the heightened risks involved in investing in a company as well as associated costs and trade-off given the scarcity of resources. Noted that any impaired investments require a larger risk capital allocation and are likely more costly to hold. Lastly, if the investor is in the same industry, then they may consider whether they can benefit from mutual cooperation with the invested company, which may be negotiated on favorable terms. For example, the achievement of vertical or horizontal integration in the supply chain as part of the investment terms. They may also consider whether they can gain access to valuable assets, intellectual property, know-how, or talent held by invested companies. They may also consider whether they can consolidate equity control over the company with a view to consolidate market share. This means that the investment may sometimes be opportunistic or predatory in nature. especially where the company is struggling from a cash flow perspective. For example, the investor may negotiate onerous undertakings and covenants, which upon default would give them a right to acquire shares of the company at a material discount. In the event of management of the company has determined to raise funds from investors, they may reach out to potential investors directly, and these may include persons or entities the company is familiar with, such as existing shareholders or creditors. Or in the absence of obvious candidates, you may reach out to investment banks, financial advisors, as well as private equity funds who may, following the gaining of an understanding of the business of the company, be interested in either investing themselves or alternatively assisting in introducing or placing securities of the company to other potential investors in return for underwriting or placing commissions. When exploring options with prospective investors, the company should have a clear understanding of the investment objectives of the investors. If they are merely desiring to be passive investors with a view to seek financial returns, then they may be concerned with mainly gaining information access or the right to participate in major decisions and reserve matters which may potentially affect or dilute their interests. However, if they have a strong view on the business operations or vision of the company, then they may request participation in or an overhaul of management operations, and in some cases, reorganization and other terms and conditions linked to the investments may also be considered. The obvious advantage of raising capital from existing shareholders is that it will typically not require material due diligence to be carried out. So what are some methods for raising funds from existing shareholders? One such method is rights issue. Rights issue is an offer by way of rights to existing shareholders which gives them a right to subscribe to securities pro rata in proportion to their shareholdings, with those who do not participate, by not accepting the offer, having their shareholding diluted. Under the company's ordinance, directors of a company may allot shares or grant rights to subscribe for shares of a company without seeking shareholders' approval in respect of a rights issue. And this makes rights issue a preferred option for capital raising when a company has a large number of shareholders, where the seeking of shareholders' approval could become a logistical nightmare. This is in particular where some shareholders are not easily contactable and potentially lead to delay in fundraising, which is not desirable, in particular when funding needs are in fact urgent. As a Hong Kong private company could not have more than 50 shareholders, the company could rely on private placing exemptions under applicable law, and no prospectus would be required to be registered, and no authorization from the SFC would be required to be obtained in respect of the offered document. This is, however, not the case for a listed issuer, and we'll discuss this in more detail in webinar 3. Key formalities involved in the right issue include the obtaining of board and shareholders' approval for the right to issue, circulation of right to issue document to shareholders containing the offer and acceptance forms, tendering of acceptance letters and subscription forms by accepting shareholders, submission of return of allotment by the company in respect of the allotment, and issuance of share certificates and updating of register of members. A further method of raising funds from existing shareholders is by negotiating loans, such as straight loans, secured loans, or convertible loans from existing shareholders based on such terms and conditions as may be agreed. Typically, this is one of the most expedient way of raising funds involving less formality. However, the company would have accrued more repayable debt, which means that its financial position in the company may not necessarily be enhanced, and the accruing of more debt may also impair its future fundraising capability. For lending shareholders, if the debt is unsecured, then the loans are junior debts which are ranked in lower priority of distribution in the case of winding up of a company. The tax implications of making a loan should also be considered. For example, interest income for the shareholder and any waiver of shareholders' loan would be taxable in Hong Kong. Formalities involved in seeking shareholders' loan would typically include the seeking of board or shareholders' approval, execution of loan and security documents, and if security is created to secure the loan, registration of charge and updating register of charge. A company may also raise capital by issuing and allotting shares or securities, and this may be extended beyond existing shareholders to third parties. Relevant equity which may be offered include ordinary voting shares, preference shares, and convertible bonds. For the issue and allotment of any shares other than in respect of a right to issue, the company's ordinance require the company to first obtain prior approval, and such approval may be by virtue of either a general mandate or a specific mandate. A general mandate is a pre-approval typically given by shareholders in an annual general meeting, which empowers directors to issue and allot a prescribed number of shares in the period leading up to the next annual general meeting, whereas a specific mandate will be an approval given by shareholders in respect of a particular issue or allotment of shares. Other formalities typically involved in an issue and allotment of shares include entering into of subscription agreement or application letter, filing of a return of allotment with the company registry, issuance of share certificates, and updating of register of members. Other than ordinary shares which may be issued, preference shares which carry a preferential right to dividends and/or distributions in a liquidation ranking ahead of ordinary shares may also be considered. Depending on the specific terms that may be negotiated, preference shares may or may not carry voting rights, may or may not be redeemable at the option of the company, or convertible into ordinary shares at the option of the holder. And they may enjoy other rights not available to holders of ordinary shares, such as the right to appoint directors, information access rights, etc. Where the company does not have an existing preference share class, or if a new preference share class with different rights is required to be established, then it may be necessary to cause an amendment of Articles of Association of the company to create a new preference share class. This would require obtaining of approval of shareholders, as well as filing to be made with the company registry, in addition to other formalities applicable to issuance of ordinary shares. A third type of securities which might be issued are convertible bonds, which are debt instruments issued by a company with an option for the bond to be convertible into shares of a company at a pre-agreed price. Such conversion rights is typically exercisable by the bondholder or the company upon occurrence of certain prescribed events. Convertible bonds may be a particularly attractive instrument for investors, as their terms and conditions can be flexibly negotiated. Further, convertible bonds does not only give the investor the benefit of a fixed rate of return from fixed rate coupon, as well as return on capital upon maturity, but the embedded equity call option, being the equity component, gives the investor an equity upside potential in the ordinary shares of the company. Such equity component, commonly referred to as optionality, is particularly attractive, especially where the value of the company is expected to recover. For example, if the financial distress is event-driven, which is temporal in nature. A further benefit of convertible bonds compared to investing in ordinary or preferential shares is that it has preferential ranking ahead of ordinary and preference shares in the liquidation of the company. Typically, the coupon rate will be higher, where the conversion premium, being the price per share upon which the embedded option may be exercised, is higher, given that a higher conversion premium is more difficult to achieve, especially for a company in financial distress. From the perspective of the company issuing convertible bonds, it may benefit from the following. First, investors would typically accept a lower interest rate than plain vanilla bonds given the added value of the option. Second, the company would not be required to repay its borrowings upon exercise of the embedded option. And third, early redemption rights may be negotiated to bring an end to giving up control of shares. This is typically at a premium, however, in order to compensate the relevant investor. However, one key downside for the company in issuing convertible bonds is that it is practically forward selling its ordinary shares, which may lead to dilution of existing shareholder stake and may put pressure on a company's share price and impair its future capital raising capability. Given the debt and equity elements of convertible bonds, its terms would typically include provisions relating to credit protection, which may be in the form of negative pledge against the carrying out of certain activities such as raising of capital, or the acceleration of repayment upon certain events of default, such as default or failure to pay coupon. Its terms would also typically include mechanisms to protect the equity call option's value, include adjustments to conversion price in the event of capital reorganizations, dividend payments, distribution of assets, cash or non-cash assets to shareholders, or further issuance of shares at undervalue. As the value of optionality decreases over time when the option approaches expiry, In some cases, optionality adjustments provisions may also be negotiated. Formalities involved in an issuance of convertible bond include the entering into of convertible bond instrument, which may be constituted by way of deeds with terms and conditions attached, obtaining of board and shareholders' approval to allot convertible bonds, as well as shares to be issued upon exercise of conversion rights, filing of a return of allotment of debenture to the company registry, and further filings of return of allotment of shares upon exercise of the embedded equity option. In all of the above capital raising options, the company should also review its existing contractual undertakings binding on it, such as reserve matters in shareholders' agreements and negative pledges in loan agreements, when considering the method of raising capital. So we have so far discussed some options to raise capital and extend debt with a view to ensure the company has sufficient funds for its operations. A further method to achieve a retention of its capital is to adjust its dividend policies and undertakings concerning dividend payments. And I'll pass the floor to Julia to talk about this.
Thank you very much, Calvin. Well, quite often, dividend policies that are entrenched in the Articles of Association of a company or provisions that are in a shareholders' agreement binding a company require the company or its shareholders to procure the payment of dividends based on a predetermined payout ratio. These sort of binding obligations to pay dividends may potentially make any debt restructuring or fundraising of the company somewhat unappealing, as creditors and investors may not like the idea that the benefits of the capital contributed or any latitude granted are not being retained or used to ensure the sustainability or future profitability of the company, but rather may be paid out to the owners or even exiting shareholders. So it may be necessary for any restructuring proposals to include a moratorium on dividend payments. This may involve the passing of special resolutions to make amendments to the Articles of Association of the company if the relevant dividend payments are entrenched in the articles, or obtaining the waiver of rights to dividend payments if the relevant rights are in shareholders or joint venture agreements. In order to preempt the need to seek an amendment to articles or a waiver from shareholders, any dividend policies entrenched in articles or provided for in a shareholders' agreement could be qualified in the following terms. First, that any declaration of dividends would only be permissible in compliance with applicable law. In this regard, the company's ordinance requires that distributions may only be made out of distributable profits and not out of capital. Distributable profits mean accumulated and realized profits, including profits arising from revaluation of assets and financial instruments, which has not been used under relevant accounting principles, less any accumulated and realized losses which have not been written off. So distribution of dividends would naturally be restricted in the event of a company in financial distress due to accumulation of material losses or similar. For Hong Kong listed companies, distributions are only permitted if its net assets are not less than its called up share capital and undistributable reserves as disclosed in financial reports under the listing rule requirements. And secondly, to the extent the distribution does not reduce the amount of these assets to an amount less than the aggregate. Further, the dividend policies should specify that any decision to declare dividends should be subject to directors' discretion in the exercise of their fiduciary duties and duties of care and diligence, and naturally that would mean ensuring that a company would continue to remain solvent. Thirdly, the dividend policies may state clearly that in determining whether to make any dividends, the directors are empowered to consider the company's immediately cash flow implications, continuing ability to pay its debts as they fall due, capital commitments or expenditures, which may be important for the implementation of its strategy and future development, as well as any other factors which the board may deem to be relevant. So this concludes our discussion regarding informal workouts. I'll now pass over to Gwyn, who's going to talk about court-assisted restructurings.
Thank you, Julia. So let's proceed to, as we said, the court-assisted side of things. So the informal workout either didn't work or wasn't viable. Obviously, one of the particular drawbacks with the informal process is, as I said before, you can't force creditors. Also, sometimes it's just not practical when you have lots and lots of creditors to deal with. Trying to do informal negotiations with a huge pool of creditors is very difficult. Unfortunately, Hong Kong does not have a very good corporate rescue and restructuring system in comparison to other sophisticated jurisdictions. We have the scheme of arrangement system here, but it's not as good as it could be. It does provide, for example, a moratorium, but only after the scheme has been approved, and therefore you've got a lag between proposing the scheme and actually getting approval, assuming you can get the approvals required. Now there are solutions to that. We'll touch on that in a moment, but I say it's not as good as other jurisdictions. But I say we work with what we have. So for dealing with the scheme of arrangement in Hong Kong, so you have an approach where you have to try and come up with a scheme and get various classes of creditors to approve that scheme. And until you've done that, you cannot get a moratorium. The moratorium prevents dissenting creditors from rushing off to court and putting the company or applying to put the company into liquidation, for example. Now, historically, the solution to that in Hong Kong was to apply for a provisional liquidator to be appointed and then get the benefit of the stay on court proceedings that came with that provisional liquidation appointment. Now, as many of you will know, Court of Appeal ruling some years ago confirmed that the way legislation is written in Hong Kong, you cannot have a PL for the purpose of facilitating a restructuring. Therefore, what has happened since then is that while scheme of arrangements have still been put forward, provisional liquidations need to receive an appointment on the classic basis of risk to assets, immediate jeopardy to assets, and then within that application then tack on a request that whilst the PL is there, perhaps the PL could consider whether there are viable restructuring options available. Like I say, this stands in contrast to other jurisdictions, such as, for example, the Cayman Islands, which does allow PLs for the specific purpose of enabling a restructuring. Now, the approach to the scheme of arrangement is, say, it's important to get the necessary votes from all the classes of creditors, and that's sort of 50% in number who are attending the meeting and 75% in value. The issue of class can be a fraught one. You have to get those approvals from each class of creditors. This can be a fertile ground for dispute. There are various occasions when creditors would much prefer to be in a class all on their own, because that gives them outsized power. And you can often see disputes arising as to who is validly in each class. The test of which class you fall in is on the legal substance of the underlying debt. So it's not just someone has a different view on the merits of the scheme of arrangement. It's a legal test based on the nature of their debts, and so you have to certainly consult very carefully with the legal team and review the various documents that are governing the various creditor positions that the company is exposed to. Now, if you do get the necessary approvals, then the scheme then becomes binding on all creditors, even the ones that were opposed. So this is your option to avoid further dispute from the creditors. They get bound, even if they don't like it. So you do have to go through that process. The court here does have a close supervisory role. You've got to get the court approval in relation to holding the meetings and then sanctioning the scheme once it has been approved by the creditors. It's basically a four-stage process to getting that scheme of arrangement up and running, and the first step is to put that proposal together. And referring back to what we discussed in the informal workout process, you've got to have a good plan. It's no good just saying, well, hopefully it'll all get better. There has to be a detailed analysis of what problems the company has encountered, why it is in the difficulties that it is now facing, what are the solutions that are proposed to rectify those issues. What effectively had to persuade the creditors is that the outcome under the scheme of arrangement plan gives them likely a better outcome than if the company went straight into liquidation. And so as part of the process of preparing the plan, expect to see a scenario comparison showing the alternative outcome if the company went into liquidation. Now, moving on to the proposal itself, we won't go through everything in detail here, but again, just to stress, this is one of the fundamental points of getting a scheme of arrangement approved is this full, fair disclosure that's taking place. So again, you have to properly explain to the creditors what is being proposed in the plan, what is the consequence for them, what is the company going to do about it. You can't just hide things away in tiny small print somewhere in a document that's not available unless they specifically ask for it. Your documentation has to clearly set out everything so that the creditors can reach an informed decision. And this is what the court looks at in the approval process, is when the creditors were voting the scheme, were they able to give informed consent to the proposed scheme. Now, in terms of the approval process, I say we obviously get to the meetings held by the various classes of creditors, and then one goes to the second court hearing for sanction of a scheme. It's important to recognise that this is not a rubber stamping process. The court wants to see that the statutory requirements have been met. And again, we get back to the question of, are the classes correctly constituted? As I mentioned earlier, the test about who falls into which class is about their legal rights, not whether creditors have divergent views on the merits of the scheme of arrangement. If the court is satisfied that the various classes have been properly construed, it also wants to be satisfied that each meeting was held properly. There was no attempt to subvert any of the creditor processes, and there's no irregularities in the conduct of the scheme. And again, the creditors were given full and frank information so that they could give their informed consent. If you get through that, then the court then sanctions the scheme and it can proceed. With that done, there will be a scheme administrator in place who will monitor the performance of the scheme. There will be various reports provided. The company carries on through to implement the terms of the plan, and hopefully all being well, the plan works as intended. That then enables the company to emerge restructured with its debts now manageable and its capital revised and on a much stronger footing so that it can continue as a viable entity going forward. If you sort of look at the pros and cons, well, so from Hong Kong's perspective, it's sort of the pro is it's the only thing we've got to bind the dissenting creditors. So it's not as good as it could be, but that's what you have to work with. So on the downside, as I mentioned, you don't get the moratorium until you've got the approval process, and so particularly if you don't manage to persuade the court to appoint a provisional liquidator in advance, you're still exposed to the risk of action, strategic action, particularly by smaller creditors who can threaten to rush off to court and put in a winding up application, and then one has to work out what can be done appropriately to address those creditors. Again, there are difficulties with the classes. It can be fertile ground for dispute, particularly when you have aggrieved creditors in those different classes. And obviously, because it is a court-driven process, it can take several months to get properly set up, and it is costly because you're necessarily going to have to involve much more time from the lawyers, the financial advisors, etc., to get everything properly in place to enable that scheme to proceed. Now, as we mentioned, the problem in Hong Kong is the provisional liquidation is now one has to have a reason other than restructuring in order to get a provisional liquidator appointed. If you do get the provisional liquidator appointed by persuading the court, say there's a threat to assets, etc., then that does grant the company that breathing space to put together its plan and prevents individual creditors from taking precipitate action which would harm the planned restructuring. An interesting contrast, though, is that whilst it's not possible in Hong Kong to appoint a provisional liquidator specifically for the purpose of a restructuring, in other jurisdictions, as I mentioned, for example, in the Cayman Islands, you can appoint a PL specifically for that purpose. Hong Kong is very good at recognizing foreign appointed liquidators. And so when you see arrangements where Cayman PL, despite it being appointed to facilitate a restructuring, is nonetheless recognized in Hong Kong. So one of the things to be looking at is whether there is an option, given the particularly company's group structure and corporate structure, whether there is a basis for going to the Cayman court. For example, and the classic there will be you have a Cayman Islands company which happens to operate extensively in Hong Kong, and the Cayman court would have jurisdiction there. So you could at least consider appointing a Cayman PL and then come to Hong Kong for recognition. These the offshore, the PL appointments are light touch liquidators. The basis for calling them light touch is, again, because they are there to facilitate the restructuring process. The terms of their order can be carefully defined, and that allows the directors to maintain day-to-day control of the company, whilst the PL supervises the process, and that enables again the company to continue functioning. It provides the protection that is necessary for the company, but it also means that no unnecessary costs are incurred and avoids the problem that can sometimes be triggered of a liquidator stepping in and making changes that might impact how the creditor relationships work, particularly again if you're talking about an agreement and a negotiation with those creditors. The term liquidator, though, obviously carries some negative connotations to it in this part of the world. And so despite the PL light touch nature, it is still sometimes looked at with concern. That is something I think Cayman is seeking to address by having a court-appointed restructuring officer role. It remains to be seen how effective that is in terms of addressing those that stigma, and indeed what the consequence would that be for any recognition applications, etc. But in the meantime, I say where they are available, the light touch PLs are a very effective tool to facilitate that restructuring process. We're going to sort of round out to talk about liquidations. This sort of completes the cycle for businesses. The first option is actually just deregistration. It's something that does not get talked about quite as much as it should, really. But it is an option that is available to companies which have either not traded or have actually completed their trading and have not undertaken any activity in the preceding 3 months and have no assets, immovable property in Hong Kong. It's a fairly administrative process. but it doesn't require lots of professional support and assistance as long as the management are on top of the company's affairs. The main delay to it is obtaining the tax clearance that's required from the Hong Kong Inland Revenue. Once that's done, obviously any surplus cash is distributed amongst the shareholders, and then an application goes into company registry with the appropriate fee. And if nobody objects, then the company is deregistered. That process takes about 9 to 12 months. And again, the primary delay factor there is how long it takes to get that tax clearance from the revenue. More regularly used version is the members voluntary winding up. This is done more often than not when the company has just fulfilled its purpose and just needs to be wound up and its affairs adequately dealt with. This is triggered by the shareholders, obviously on the recommendation of the directors, passing a resolution to liquidate the company. And the directors have to swear a declaration of solvency, confirming that the company is capable of paying its debts. And then the liquidator deals with the company's assets, pays out creditors. Again, those will have to be paid in full. And then the company is closed down. Now, again, the importance here in terms of the time frame, you see it takes about 7 to 12 months. The big delaying factor is, again, getting the tax clearance from the revenue. And so, interestingly, there's not terribly much time frame difference between an MVL and just deregistration. The benefit of an MVL over a deregistration is because you're formally going through the process of calling for creditors to prove their debts, setting a claims bar date, etc., you are definitively clearing up the company's affairs. By contrast with deregistration, any aggrieved person can apply to reinstate the company for up to about 20 years, and therefore, whilst the company might be deregistered, it can potentially be brought back to life later down the line, whereas an MVL process helps to clear everything out. Also, again, depending on how well the company's books and records are maintained, if you go through a deregistration process, if any assets are forgotten about in that process, so they're still owned by the company at deregistration, they pass bona vacentia to the government. One of the duties of the liquidator, the MVL, is to properly deal with all the assets, hunt them down, and realise them for the benefit of first the creditors, and then the balance goes to the shareholders. After the MVL, another option is the creditors voluntary winding up. This is often referred to as the insolvent company winding up, but it arises. Obviously, the shareholders still trigger the winding up, but it arises also when the company directors are unable to sign a declaration of solvency. Now, obviously, that naturally arises if a company is insolvent. The directors are not going to sign a declaration of solvency. But it can also arise where the company's position is uncertain, particularly given the nature of the assets, the ability to realise those assets, or the value at which they may be realised. The directors may not wish to sign the declaration of solvency. So in either event, some of that declaration, then creditors eventually winding up takes place. So after the shareholders have resolved liquidation, the shareholders will appoint a liquidator. Control shifts to the creditors. They have the option to appoint somebody else as the liquidator, or continue with the liquidator the shareholders have appointed. But again, the key tasks there for the liquidator are to investigate the company, take control of its assets and realise them. If it's insolvent, then they're only going to be paying out the creditors. If they happen to have a great result and recover more than expected, are able to pay out all the creditors in full, there's still prospective distribution to the shareholders, but more often than not, again, because the company is usually insolvent, it's only the creditors that receive anything, and that is why the creditors have effective control of the liquidation. The time frame for this is effectively driven by how long it takes to realise the assets. In a relatively straightforward liquidation, it could also be 9 to 12 months, but where you're dealing with complex assets, particularly if litigation is involved, then it could last a number of years. And then we also obviously have the court liquidation process. Now we have several slides here with the detailed steps, the various powers. I'm not going to read those out to you. As I said earlier, the slides will be shared for that at the end of the presentation. But the court liquidator has very wide powers to investigate the company and to deal with the assets. And we mentioned earlier the prospective of provisional liquidator if there are concerns about risk of jeopardy to the assets. The one thing I just did want to touch upon, just bringing us back into the restructuring and rescue space, is in the appropriate circumstances, the liquidator may form the view that some of the business is worth saving and so can viably be traded out, continue to trade whilst a buyer is sought, maybe a strategic purchaser, competitor, etc. And in the right circumstances, that may still be a route to save some of the business. So it's not automatically the case that a liquidator just comes in and turns off the lights and shuts everything down. Again, if there is potentially a viable business in there, a liquidator in the correct circumstances can look at options to rescue that aspect of the business, again, to generate a better return for the creditors. I think with that, I'll pass to Julia.
Thank you, Gwyn. So that brings us to the conclusion of the formal part of this presentation. As I mentioned earlier, this is part 2 of a 3-part webinar series. Webinar 3 will be next Wednesday, 31st March at 5 o'clock, and will continue the discussion of different restructuring mechanisms and the regulatory requirements for Hong Kong listed companies. You're most welcome to join us. You can find the link to register on our website. So thank you again for being with us today, and we do hope we'll see you next Wednesday. Have a great evening.